So Zach, I have been waiting 8 years to ask you a question. Are you ready for
Okay.
the question?
Yeah, I'm nervous, but
No, it's okay. Nothing to be nervous about.
yeah.
What did you think when you saw me sitting in the back of the courtroom at the 2015 Orcs, allegedly transcribing your round?
Wait, what? What is this?
You haven't seen these? You haven't seen this?
If I have, I don't remember it. Uh
Everyone's getting Zach's live reaction to the
yeah,
confession about Delaware and Harvard.
I have no memory of this.
Okay, well, that's good. So essentially, the story is that Delaware had two teams with bids to Orcs, one in Greenville and one in State College. The State College Orc was before the Greenville Orc that year, and that's where you guys were. So we traveled with our B team to watch the Orc, and we
Yeah.
would figure out what the best rounds were, each round, and some of us would watch whatever those rounds were, and observe. Um, so one of the rounds, I think it was round one or two, was Tufts v Harvard, which is an excellent round any year, but especially this year because this was the Harvard team that everyone was talking about that was just steamrolling people throughout the season. So me and Ryan Leonard and Andrew Donnelly, my teammates, sat in the back of the room, and we did have laptops, but we were not transcribing. I remember the people were very upset after that we were there.
Hmm.
And then I guess somebody went to confessions to voice their displeasure. And I always wondered whether you noticed. I guess the answer is no.
No. I mean, we I think year to year changed views on scouting, candidly. I remember being on some teams where it was like, oh, we hate scouting. We would never scout other teams. And then other years it's sort of like, these are open trials. You can learn a lot about opponents. Yeah, this is interesting.
Well, I'm here to tell you 8 years later that we were not transcribing your round. We were not typing anything that you guys were saying. Although I will say that we were really sort of intrigued to be there, and it was it was an awesome round. And the reason we were in that trial, candidly, was because, like I said, this was as dominant of a year as I think any team had at that point, as long as I'd been involved, and certainly has had since, in terms of just a wire to wire dominance of the season. Your 2014, 2015 Harvard team that went on to win the national championship. And we're going to watch a portion of that round today. But before we do, I want to just talk about the season and sort of how we got to that final round. So
Sure.
this was your senior year, right?
It was. Yep.
So you'd been to nationals all 4 years. In 2012, you guys were second in the division, 7-1 behind Rutgers. You won your first
Yeah.
All-American. In 2013, you were 8-4, fifth in the division. In 2014, you were second in the division again, 10-2 behind Princeton. So really crazy behind Rutgers and then Princeton, two teams that sort of came out of nowhere that year.
Yeah.
And then you guys get it done in 2015. I should also add that you won
Finally.
an All-American in 14 and then again in 15. So 4 All-Americans if you count being in the final round. Did you guys feel like going into the 2014-2015 season, it was win the national championship or bust, given how you done?
Yeah. Yeah. I think, I mean, like the context of the year before, I think is kind of important. Folks sort of knew that the team had been through something pretty serious the year before. So teammate Angela Matthew had died in early 2014. We were driving back from a tournament. It was, I mean, honestly, I think we all kind of view life as like before that happened and after that happened. And obviously that context gets lost in, this silly trial activity, but I don't think any of us would have come back except to do it all. And so 2015, I think we started the season thinking, we want to try to do as well as we can. We want to have a good time, but we had also been bonded together by something that I think was so much bigger than mock trial that there was a lot of emotion baked into what we were doing when we came back that year, I think.
So, for those of us who didn't know Angela very well, or at all, she was a witness, I believe, right on your A team.
She was incredible. Yeah, she tended to play our victim characters, but she also had this like hilarious, really funny side, and so she could do kind of zany characters as well. And I mean, she had been lights out at like every tournament that we went to with her. And yeah, I mean, it was just one of those kinds of freak things that you obviously never want anybody to go through, but particularly, I think at that stage of life, it was shocking to everybody involved. And, you know, some of my closest friends, people that I like love to this day and hopefully will work with in the future, like continue to see pretty often. You know, we all cared deeply for her. And so, yeah, I mean, I guess I say that because it's like context that I can't separate from what ended up happening, right? Like you watch these videos and, you know, we're sort of robots on the screen, and obviously we're trying to do as well as we can within the confines of this game. But that motivator was absolutely something that was in the back of all of our minds.
And just to sort of put this into even more context in terms of the timing, my memory is that she passed away your junior year, so the year before this. Am I remembering that correctly? And at what point in the season would that have been?
We were driving back from the regional tournament in 2014. So we were
so the tail end of the 2013, 2014 season. So it was like you said, like kind of not quite right before your senior year, but like sort of towards the end, which set the stage for, you know, for your last year. And obviously, like you said, that must have been really hard. I would imagine that most of the people on your 2015 national team were her teammates on a team with her, right?
Yeah, absolutely. I mean, and people who were even more immediately involved in the accident and like that tragedy than I was. So yeah, I mean, every person on the team knew her in some way, was somehow impacted by this. And you know, we're at the like most stressful period of college, right? We're writing our thesis. We are like maybe some of us applying to law school. You know, it was a huge moment of life. And then to have this like immense weight of, well, now we've done pretty well this season, so we need to win mock trial. I remember it being, I think you said like win or bust. It felt like in a lot of ways, we were more stressed about not winning than we were enjoying the wins round around. And so a lot of the sort of enjoyment got lost, I think, along the way.
Did you guys consider in 2014 not competing at Orchestra Nationals?
Yeah, definitely.
How hard of a decision was that for you guys to decide you wanted to compete at Orchestra Nationals?
I mean, incredibly. And I think, you know, I don't want to speak for anybody else on the team. Like you really should talk to everyone about like how they sort of processed things. It was incredibly difficult. I think for those of us who did compete that season, to get that close and just come up short was, yeah, I mean, it sucked. We never got the chance to see that Princeton team. From what I hear, they were great, but you know, we won 4 rounds, I think by pretty sizable margins, and didn't get a shot in the national championship. I think the 2014 team, in some ways was as good, if not better than the 2015 team.
Who did you guys graduate from the 2014 team?
Christina Tester, she was an attorney witness. Graham Wyatt, he was an attorney witness. Florence Chen, she was my year. She didn't come back. I think the rest of the team we had.
I mentioned that you guys were second place in the division your 2012, your freshman year, so 2012, 2012. Or no, is that 2000 or is that 2013?
It was 2012.
Okay, so,
yeah,
that's the Danny Dawson case was your first case.
Yeah,
because you and I overlapped exactly. We were there the same 4 years. Yeah. So in 2013, you guys made nationals as well. And I don't know if you probably don't remember this, but at the, I guess the Philadelphia org, I think it was the Philadelphia org. We were 5-1 going in round 4, and my Delaware team had never made nationals, and we had a really good season, won a bunch of invitationals, 5-1 going into the last round. And I think the rules at that time is that you were power protected at 5-1.
No, were you guys the round 4 team?
Correct. So we're 5-1 and we're power protected. So we're good. All we need is one ballot in a power round. Yeah. We're good. And we draw 3-3 Harvard.
Yeah.
Like the odds of drawing 3-3, a 3-3 Harvard team who's like historically good, and just randomly ends up being 3-3 by dumb luck. And we drop both ballots to you guys, and you guys I think got one of the last spots to nationals, and
Yeah.
we were the last team out.
But what you don't remember, and I am now remembering that round, Phil. What you don't know is that we were certain we were gone. Like that round was just we're just going to have fun. Like let's like pedal to the metal, but we know we're out. And our B team, as I recall, they were in a better position. Maybe they were 4-2 or 4.5. We thought they had a good shot to get a bid out, and we had made the decision the night before. Like if the B team gets the bid, they're going to go. This is it for us. And we had a senior on the team that year. We basically had our like farewell before that round, and I was in the rental car going back to drop it off. We weren't even or most of us weren't at the closing ceremony. So we were certain we were done from that tournament.
I hate when people complain about bad luck, but it's not possible to have worse luck than being in a power protected round and drawing a historically good Harvard team. And the other reason I bring that up, because you mentioned Graham Wyatt.
Yeah.
I remember in my 4 years competing in AMTA, the best attorney I ever saw live was Graham Wyatt. And I remember, I don't know if it was because I hadn't been in many high level AMTA rounds at that point, because Delaware had just really gotten good. And that was sort of the first really, really good team I saw. But I remember he cross-examined Frankie Fernandez in the Neptune case. And I remember watching the cross and just thinking, I've never seen someone this good.
Yeah, Graham's great.
If you had asked me probably as a senior who the best attorney I'd ever watched was, I would have said Graham for sure. And so he's certainly a big loss. And you guys, getting to the next year, losing all those seniors, especially him, was a tall task.
Yeah, it was huge. Graham, he always had the perfect sort of let's take a step back here defense opening. Like he would win that opening 2-3 points a ballot regularly. I think he had the like sort of Midwestern charm, hold up here. And he, so many things that I see from mock trialers today, I identify as like, Graham used to do that incredibly effectively.
He always felt like much older than me too. Maybe because he actually was much older than me, but he wasn't that much older than me. He was like 2 years older at that point at most. And he just felt like an adult, and we felt like children.
I mean, part of that is the height, right? He's like 6'3" or 6'4". Yeah.
The other thing I remember from that round that I still talk about to this day is Ryan Leonard was playing Jordan Nelson, who was the like weather expert. It was like a dive case involving, there was like a hurricane. I remember one of your co-counsel asked Ryan like a gotcha question on cross. She was like, has there ever been a hurricane that was like, or can you name a hurricane that was like that severe or something to that effect?
Yeah.
And Ryan said, I don't think there was one. And she said, actually, a Hurricane Sandy was something like that. And that's when we knew we probably weren't going to nationals, but that team was really, really good. I want to talk about the 2014-2015 team specifically now.
Yeah.
How many invitationals did your stacked A team do that year?
The stacked A team, we just went to GAMTI and NYU downtown.
And how'd you guys do at those tournaments?
We won both. But I think the ballots lie about how close it was both times. The fourth round at both of those tournaments, I think we all thought we had lost each of those rounds.
And who were they against?
Tufts was the first. This incredible team that had Nick Teleke, Mandy Zhu. It was a lights out team. They were so good. We were certain we had lost that round, and somehow we didn't. And the second was against Miami, Ohio. They were also incredible. So I don't know, like ballots can always break both ways. I think in the end, it looks like we dominated the season. I think in the moment, either of those rounds easily could have been on the other side of a coin flip. Yeah,
we saw Miami at nationals that year. They were, I think, second or third in the division that year, and we saw them at nationals in round 2, and had a really, really good round with them, and they were really good. I totally agree. So you guys win the only 2 invitationals, which at that time, for those who are watching and don't know what the invitational circuit was like at that time, GAMTI and downtown hands down were the top 2 invitationals by like a lot, I think, at that point. And you guys won both. And then did really well at regionals and Orcs, obviously. I think you were 7-0-1 and 7-1 at the other, right?
That sounds right. Yeah. I don't think we lost the ballot at either. Yeah. So, or maybe we lost one at regionals. Yeah.
So you guys had not really done a ton of invitationals together, but you did the best two and did really well. So going into nationals, I remember the feeling was that this Harvard team has run over everyone this year, and they're probably going to run over everyone at nationals. And that's kind of what happened. How did you guys feel going into nationals that year, given how things had gone the previous 3 years and also that season?
Yeah, I mean, we had been so close so many times, right? So, like you said, 2012, like right there on the cusp. 2014, right there on the cusp. We couldn't break into the final round either of those years, and I remember feeling frustrated that both of those years we couldn't like win our way into the round, right? The team had, I think, in 2010 had made it to the national championship and lost. Maybe I have the year wrong. It was against NYU. But Harvard had like been a really great team for a really long time and had never won. And it felt like, okay, well, if we're going to do it, it's time to really put in the effort. And we feel like we've done a really great job with this Park versus Duran case, which is a really fun civil case that involved this like child shooting incident. I realize there probably aren't many videos of it because this was the first time that we have a brand new nationals case. And so, like, going into nationals, honestly felt really stressful because now we have this brand new case. We have to come up with material from scratch. As I said, it was an incredibly stressful time for all of us, right? Like trying to get through the end of the year, and you've got a month to put together everything, sort of from the first step. And yeah, I mean, to my memory, we were practicing basically every night, like 10 p.m. to 2 a.m. It became borderline obsessive, I would say, for the last couple of weeks. And in subsequent conversations that I've had with Justin Bernstein about it, that the decision to change the nationals case, I think long term looks wise, and I think it's produced better mock trialers at the national level. That first year, I think there was an adjustment period because nobody really knew what it was going to look like when we got to that tournament. And I think that context has kind of gotten lost.
Yeah, I think obviously the teams have gotten better at it over the years. And it was certainly a radical idea at that time. And I remember, we were at nationals that year and feeling similarly, like, how are we going to do this in 4 weeks?
Totally.
But sort of, the way that Justin always says it is you can do it. And these teams are talented and they'll rise to the occasion. And I thought, all of the trials that we were involved in at nationals that year, I think for the most part, the teams were just as good as they would have been had it been the same case.
Yeah.
One other question that occurs to me in the context of sort of the new case versus regionals case discussion is, I remember the discussion at that time was, well, this is going to benefit the teams that have large coaching staffs like UVA and Miami and schools like that. And you don't really hear much discussion about that these days in the context of like, well, if this team has a lot of coaches, they're going to do well at nationals because of the new case. Because that really hasn't been the way it's shaken out over the last 8 years. Did you guys have a coach or coaches at that time?
No, we never had a coach. I think Harvard still has never had a coach. Alums would come in to judge a scrimmage, but at the collegiate level, I really never felt like quality coaches really made a difference. I mean, maybe like in building a program long term, right? Like you look at Rhodes or UVA, like obviously Miami, like obviously there are programs that have benefited from having like solid coaches who really understand the activity. But I think especially with a brand new case, like the students have to know the material so well. They're like living it. They have to, throw together an opening and a cross and a direct for multiple witnesses in a couple of weeks. I don't think coaches really make that much of a difference at the very end.
So I'm going to push back on that because I've had this debate with people on the show a bunch, and maybe when we watch this in a second, you may have, we can talk about it in the context of actually seeing the cross. But my guess is if you, Zach Fields in 2023, are the coach of the 2015 Harvard team, my guess is the team's even better because obviously you're just as talented and you're going to do 95% of the stuff you would have done just as well with or without a coach. But on the margins, I think having a coach who can sort of quality control, that's not really what happens in real court, or that's not the way real lawyers talk, or that's not the verbiage that a real lawyer would use, or whatever the case may be.
Yeah.
I think if you watch this round and some of the other final rounds, that happens a lot. Like I think they're, college competitors with no coach don't really understand, like rightfully so, that what's realistic and what isn't. So my guess
Yeah.
is a program like yours and some of the other high level sort of student run programs from year to year it's not to say that they're going to be markedly better with a coach, but certainly better on the margins, I think. Do you
No,
disagree?
yeah, I do disagree. I mean, it's interesting. I think you're probably right that some quality control piece would exist for a coach team. And you can say things like, that wouldn't happen in real court. I also think that when we all go to law school, eventually, for those of us who do, some little piece of like the creative mock trialer that you were gets like ground down, right? It's like, no, that's not what lawyers do. You can't be that creative on cross. You can't make that objection. You can't like do this thing on direct. And something gets lost there. And I think like if you watch this round, the Yale team I thought was so innovative. I'm not sure that a coach team would have come up with that stuff. I think like there is something to be said about the outside the box thinking that like a group of 18 to 22-year-olds who haven't spent that much time in a courtroom can do. And I think if you put too many like really well qualified lawyers in the room with them, like some of that creative spirit kind of gets lost. So yeah, I mean, like, it depends on the group of students. Like at the law school level, I think coaching makes a huge difference. But I think in AMTA, with the number of strategic decisions that you have to make, like at every turn, I'm not sure that coaching makes a huge difference.
Yeah, I mean, I'll push back on that even further in the sense that I would agree with you if the trials were being judged solely by AMTA alums who weren't lawyers or
Yeah.
lay people, right? But the rounds, especially like a round like we're going to watch, the national championship or a big round at a big invitational, they're judged by trial lawyers.
Right.
You know what? Something that you said a second ago, I think is so true, which is that sometimes I think there's a danger for real trial lawyers to step into coaching a mock trial team to say, well, that's not how we do it in a real trial.
Yeah.
And my response to that a lot of the time, most of the time, I'd actually say is, well, maybe you should, like maybe you should do it that way because it's better.
Yeah, totally.
But I do think that when I look back at our some of the things we did at Delaware, and that's not to say that we were, we are the example of what a high level AMTA team is, but we were a nationals team. I would say a typical average nationals team. And I look back at some of the strategy decisions we made and the content decisions, especially that we made, and I just think, like, I would laugh at us if I were judging us. And I wonder if having someone like you, or just a real lawyer with AMTA experience who can sort of understands the game and the strategy, like you said, to quality control that stuff. It's so interesting that people that AMTA alums are just so anti-coach. I just find it really interesting.
I mean, I'll tell you, I watched the most recent Harvard team. I judged actually what ended up being a scrimmage of the final round, which I know were also there, Phil. I talked to some of them after the fact about what I had seen. I think if they had had a formal coach, they wouldn't have come up with a bunch of the interesting strategic decisions that they made. I pushed back on some of the things that they were doing. I wasn't sure that it was strategically wise. It clearly worked out for them. I really don't buy that, like, putting good mock trialers back in the room necessarily, results in a better team.
Yeah. And the interesting thing about it, from my perspective, is when I was a college competitor, we didn't have a coach.
Yeah.
And we made nationals without a coach, and we wrote the content ourselves, and all the decisions were made by us. And if you would have told me as a senior that we needed to have a full-time coach making all the decisions, I would have said the same thing that you're saying.
Yeah.
The competitors who come on my show as current competitors say to me all the time, which is, we don't want a coach, and we're better off without one. I think part of what has influenced me to have this view is being at a law school like Drexel, that is heavily coached.
Yeah.
And seeing sort of the benefits of that, and imagining where I'd be without some of the coaches that I've had, not just Justin, other coaches that I've had who, without a doubt, made us better and helped us improve. You coached the law school team. I know you coached UCLA for a couple of semesters, right?
Yeah. Justin has pulled in a few of us over the years, and it's been really fun. I mean, that program is incredibly dominant. Justin, I think, has become a draw for people who are really interested in doing trial advocacy stuff. I think UCLA Law School is the place to do it. So yeah, I mean, it's been great. I really think the law school sort of competitive environment is radically different from AMTA, though. I mean,
Why do you think that is?
well, I mean, like the motions practice, I think is much more akin to, you know, being in real court. I think having coaching staff can make a difference at the margins for that sort of thing. Fewer witnesses. The witnesses aren't really on your team most of the time, depending on the tournament, right? Like, I think that the Tyler model, you've got the neutral witness. I think it does feel much more like real court. It also feels much less fun in my view. I think AMTA is exciting because there's something about it that, I mean, every trial can be completely different. If you have a team like this Yale team, right, that throws a totally different narrative at you, you've got to respond to it in real time. I think in law school, every round basically feels more or less the same.
I wonder if, and see, you and I could talk about this for hours, and maybe we will. But I wonder how much of that is a function of the case writing rather than the teams. The cases, the AMTA cases are much more complex and intricate and detailed.
Yeah.
Whereas a typical law school, I mean, you know this from coaching, a typical law school case are like, they're like 60 pages, 4 witnesses, very few exhibits.
Yeah.
Obviously the invention rules are super, super strict.
Right.
So
I think the law school competition shows off great lawyering with minimal material, right? And I think the college competition, I mean, great lawyering certainly, but I think it also requires like all kinds of creative choices, right, at every turn. And you know, by providing students that latitude with a number of different characters that you can call, tons of exhibits, most of which are usually very objectionable. I think they just, you know, sort of amplify the outside the box potential of each round.
Suffice it to say, you definitely enjoyed the AMTA circuit as a competitor, and you know, in your time, you know, post grad, than your limited time as a law school competitor and coach.
Yeah, I think that's fair. And to give it a different twist, I remember a conversation with now Judge Heitens, Toby, when he was trying to talk me through the law school decision. He obviously has been involved in mock trial at every level, and sort of the architect of the great UVA program. And he told me the only 3 years that he was completely uninvolved in mock trial were the 3 years he was in law school. And he kind of encouraged me to think about doing the same. And I'm really glad that after, especially my 1L year, I did sort of let it take a back seat. I have some like idea that in the future, I'd love to be involved again, whether it's with high school students or college students, but I think it was important to kind of take a break.
Do you have the itch to go back and coach an AMTA?
Maybe. I mean, but like for all of the reasons that I sort of said before, I think students really benefit from having that creative space to themselves. I'm not sure I want to muck with that.
Man, we could talk about this for a long time.
Yeah, for sure.
So I'm sure we'll talk about it some more, but before we do, I want to talk about the portion of the round that we're about to watch from the 2015 national championship between Harvard and Yale. And like you said earlier, this was the first year of the new case, authored by Justin Bernstein. For those who haven't seen any portions of this round, which I'm sure are very few people at this point, what was this case about?
So this was basically an election fraud case. You had a mayoral candidate who allegedly was involved with a shady sort of fraudster that she had represented in the past to disincentivize low-income voters from going to the polls. And the plaintiff in the case was the challenger. And I'm not sure how Justin came up with the idea, but basically the thought was this lawsuit was being brought to flip the election, not to like provide a new election, but to just flip the result, to make it such that this candidate who had lost had actually won because votes in this low-income district were suppressed. So obviously, I think, you know, it's timely. We see all kinds of voting rights efforts on the downturn. And I think at that time, this wasn't something that was really on people's radar as much, I would say.
Yeah, I was going to say, you said it was timely. I'd actually argue it was maybe even a little bit ahead of its time, right? Considering the climate that we're in now.
Yeah, sorry. When I say timely, I mean, I think it's timely to 2023.
Oh, right. Okay.
I think in 2015, this was probably a little ahead of the curve for sure.
So we're about to watch your cross-examination. Harvard represented the plaintiff in this round. So the challenger in the election,
right,
who was claiming that the election results were fraudulent, and the defendant in the case was the incumbent mayor, represented by Yale. And your cross-examination that we're about to watch is of a defense witness named Jody Sandberg, who was a reporter on the campaign trail.
Yeah, that's right. Like a Sarah Palin character. I think context, walking into the cross, their direct was super fun. I mean, right from the outset, I saw, if she and Raymond Zhu just sort of went off on, sort of their standard spiel, we were going to lose the round pretty handily. I felt that way with all of their witnesses. I mean, Allison Dirk, total lights out, like incredible. And so, we had sort of huddled up to make a strategic decision that we were really going to have to win the round on objections and on cross differentials.
One of the things that you mentioned Allison Dirk, and one of the things that we saw her do that year at an invitational or at a round that we scouted, I don't remember what it was.
Yeah.
But she played the mother. So you mentioned the regionals case was a shooting where one child shoots another, and the parent of the shooter child is being sued by the estate of the child who died.
Right.
So I remember that Allison played the defendant parent of the child who fired the shot. And I remember she had a line where she looked at the jury and said something like, all day they've been talking about my child like she's a piece of evidence. She's not a piece of evidence. She's my daughter. And it was like one of the best things, it might be the best thing I've ever seen a witness do.
Yeah.
And we stole it so hard. We did not do it as well, but we tried our best. She's incredible.
I mean, I think there are two things that are true of almost every mock trial round, right? The team that is having more fun tends to win, and the team that looks like they're having more fun tends to win. And the team that makes it feel more real also tends to win. And Allison Durkin was incredible at the second. I mean, not to say that she wasn't having fun the whole time too, but everything that she touched immediately felt authentic, right? You forgot that you were watching mock trial and you thought you were watching this like actual defendant on the stand testifying. And yeah, I mean, that authenticity just can't be replicated.
We're never going to get to this cross, but I have so much. This is just so interesting to me. Like, I've said a bunch of times on the show, I'm sure it's an unpopular opinion. I'm sure I'm going to get roasted for it, but I'm not a huge fan of the over the top characters.
Yeah.
And people like Allison and people like Neil Lacha, who we're not going to watch, but was one of your witnesses in this round, are the examples of what witnesses in AMTA should be.
I agree.
You can be interesting without being ridiculous. And It was like the perfect example. He was a character. He had a shtick, but he wasn't like a caricature. He was a real person.
Totally. And I mean, he was playing some version of himself too. I think that's kind of what gets lost when people watch a video of Neil. That's like an amped up version of Neil. I think this past year, Travis Harper, what he did, that character is the same kind of thing, right? It's incredibly authentic. He's speaking from the heart. I think, I mean, what Allison did in this championship round, I thought was lights out.
Yeah, when I watch her, I've seen her a couple of times when I've watched Neil the couple of times I got to watch him. Amanda Mondell, like people who are just
Ian,
Ian, right? Just credible. Just credible, not silly. Like that's what we should be striving for. And it's just a masterclass in this round in terms of what good witnesses in AMTA should be. But without further ado, we're going to get to this, or else we are never going to end this episode. But I'm happy to stay here all night with you, Zach.
Was it played in Bellevue?
Yes. It was broadcast everywhere that the news networks broadcast.
Thank you, Ms. Sandberg. Nothing further.
Thank you. Counsel?
Yes, Your Honor. Before I proceed with cross, permission to set up the courtroom for demonstrative?
Sure. Opposing counsel seen it?
Yes, Your Honor.
All right.
Have you watched this back?
I have. It's been a long time. I hate that I just said demonstrative like that. I mean, it felt so faux mock trial. I say this to students all the time, but just feel comfortable in the room. No mock trial words.
Yeah. Like blow up or like something that's more like what it actually is.
I've got a photo I want to show the witness. Can I set it up? Something like that. Yeah.
Have you guys seen this?
Yes, Your Honor, we have.
You okay with it?
Yes, Your Honor.
Was that a real judge? I think that's a real judge.
Yeah, he is. He was incredible. He was so sharp the whole round. I mean, having a ton of fun with us on objections. He really let us go back and forth, and I respected him so much for it.
So I do ask permission to move so that I may see the monitor.
Yeah, of course. I just want to make sure you've seen it. Yes, counsel.
Can we just inquire quickly to Mr. Warren how much time the plaintiffs have remaining for the, the defense has remaining for the direct?
8 minutes and 50 seconds.
Thank you very much.
I was right there, Phil. So smart of Dan to reassert himself right at
I
this
thought
moment.
the same thing.
He was so good at like occupying the space. I was so annoyed because I knew that if we let him occupy the space, we stood no chance, right? And I think if you watch this year to the next year, he does it even better in 2016.
I was going to say the same thing. It's almost like he was like, I got to do even more in 2016 because the insane amount of sort of sucking up the energy in the room that I did in the 15 round was not enough, evidently. So I got to go even further.
There is no reason that he needed to know how much time they had remaining. I guarantee you he didn't care. But he very effectively reminded the jurors, like, hi, I'm still here, and I'm actually much more interesting than this boring guy you're about to watch.
You can just go ahead and call it out.
Yes, Your Honor.
Might as well.
You haven't even asked a question yet. We've paused it like 7 times.
Yeah.
Did you know who Dan was at the time? I don't know that many people did.
No, I had talked to him like one time before this round. Honestly, the Yale team was not on our radar, which I know sounds crazy in retrospect because the team obviously was incredibly dominant for like the next 5-6 years and still is. But heading into this tournament, I don't think we were afraid of hitting the Yale team. And then we watched Ray's opening, and from there onward, we knew it was going to be incredibly close.
I don't think they were on anyone's radar this year. I remember at Cubate the year before, we saw it may have even been like an unstacked like Yale B or something like that.
Yeah.
And Dan was on the team. And I remember I didn't know anything about him or know who he was. And I remember watching him and thinking, this guy's incredible. Like, how is he not like one of the people that I've heard of before? And so to see him go on to do what he did was in some ways pretty unsurprising. But I don't think he was Yale was not on the national scene at this point, and he certainly wasn't.
I think that's right. And they weren't, unless I'm wrong, I don't think they were invited to sort of the big invitationals, right? No. Like Gambia and NYU, which was, I think, a huge loss, obviously, seeing this team now.
Had they been in the national championship prior to this? I don't think so. Not since they've been in it 6 times. So
yeah. I don't, it wouldn't surprise me if they hadn't been.
I'm pretty sure they hadn't been.
Yeah. I just remember walking into the final round thinking 2 things. Like, one, this team was incredibly dominant in the 4 rounds that preceded. I didn't know how much of that was due to this like new nationals case thing, right? Like maybe they just had a really cool, smart like way of reading the facts. So I thought that they were probably pretty good. I also thought that they were probably going to be, if there are like 2 modes of mock trial, right? Let's say one is sort of UVA, incredibly polished, sort of what you would picture like a genteel, like proper sort of attorney to sort of sound like in court. And then the other is like the no holds barred, Wild Wild West, New York State Court, like who knows what's going to happen. I figured they were probably going to be the latter. But apart from that, we had no idea what to expect.
So it's interesting. You said like they weren't on your radar at that time, and I think that's probably right. For most people that were looking at Yale that year, I'm trying to remember. I mean, obviously, you guys were there are favorites at nationals every year, but I'm not exaggerating, and you're going to be too humble to say it. You guys were the heavy favorite that year, and as heavy as a favorite as anyone has been over the last decade.
Yeah.
And so I'm trying to think, like, were there a couple of teams who
Oh yeah,
were like, these are the teams we don't want to see?
totally. Well, Miami and Tufts, because we had seen them before, and I thought both were very capable of beating us. UVA, because I mean, just always UVA. Although, like Harvard, to that point, I don't know what the history has been like since. Harvard had a pretty good record against UVA, surprisingly. Even though UVA was a great team, we felt like we had some sense of how to break their mold, right? It was, if you just throw the round off a little bit, they're going to be unsettled enough and you'll win. UCLA, I mean, that team was always incredibly good. And I'm trying to remember, was Ian back that year? I think he was.
No, he had graduated the year before. So this was Kyle's team.
They were still on the radar for sure. And then Duke, who we ended up hitting, I think round 3, maybe.
I think it was two or three.
Yeah, we felt like we were probably going to have to beat Duke to get out of the division. And I'm trying to remember who else. Yeah, those are the teams that come to mind. But I mean, at any nationals tournament, it's the team you're not thinking about that tends to throw the whole thing off, right? It's the ballot that you drop in the first round that prevents you from ever having a shot at the final. And yeah, I can't remember, honestly, everybody that we were thinking about.
Interestingly enough, I think you guys faced Baylor.
Yeah, we
in
did.
round 4, which was a team that I think nobody thought was going to be in the mix, and they were in the mix at the end. And I believe I could be wrong on this, but I believe that team was led by Chris Clark, who was in the 2017 Top Gun final.
Yes, and
the runner-up that year.
You probably don't know is that when Chris and I were in high school, we were in the Texas State Championship high school round in 2011 against each other. He had won the year before, and my team ended up winning that our senior year. But I knew who Chris was, and subsequently, like I went to law school with Taylor. Like that team was incredible, but yeah, they weren't on our radar either.
So hopefully now we will let you get a question out before we There's Will Warren here.
May I proceed, Your Honor? Ms. Sandberg, like any good reporter, you know that it's important to follow your evidence until it all ties back together, right?
Oh, sure.
Ma'am, you spent the last few months covering the election next door in Truman, right?
Oh, that's right.
You
Yes.
spent almost all of your time in Bellevue. That's in District 12 of Truman, right?
I spent a lot of time in a lot of districts, but mostly Bellevue in March. Yep.
Now, ma'am, I want to talk to you a little bit about something that Mr. Zhu didn't bring up on your direct examination, if you don't mind.
So I'm gonna pause here, Phil.
Ma'am,
We decided to treat this whole cross as basically a direct. Like we're just gonna make this our witness. And so from the beginning, I'm almost talking past what they've done on direct. I felt like I had objected enough of it out that now I want to say, like, here's the real story, right? And that was kind of the lead in.
Yeah, so I think this witness was a swing witness in the sense that either side could call her.
Totally.
So you really, and you may have actually had to have a direct prepared in some ways, knowing what you wanted to get out of this witness if she was your witness.
I think that's right. Yeah.
I have a question for you. Why didn't you button your jacket ever?
I don't know. It felt more comfortable or something. I'm seeing now also the tie square. I would never wear something like that today. I mean, it's funny to pile on all of this context, but my grandfather had died not long before, and that was his. So it was just sort of like this, like, I'm gonna throw it on.
Did you wear it all year?
No, I think it was just this tournament. Yeah.
Do you button your jacket in court now?
Most of the time, probably. I mean, I don't know. I actually think it can look comfortable, right? I think you want to feel like you can sort of occupy the space. You're not out of place, right? You're just talking to people. And in some ways, I think open jacket can convey that. So
if you saw a competitor who you're coaching or judging with their jacket unbuttoned, would you tell them, I think you need to button your jacket next time?
No.
Even, do you think that there are lots of judges who'd be offended? I mean, I wouldn't be like offended by it, but I would notice it. Do you think that there are some judges who'd be offended by that? I know it's such a minor thing, and that's the level that we're nitpicking here, Zach.
Probably. I mean, I think mock trial is like this balance between you have to be sufficiently formal to know that you are to show judges that you understand the rules of the game and you are respecting those rules and you're respecting being in court, but you also want to be colloquial and conversational, and you're always on that knife's edge, right? And I think like if you have established, so like to sort of take your question at face value, at the start of a trial, I would probably button my jacket. Once you have established I'm in this space and I'm just here to talk to this witness, I think it's totally appropriate to go this way.
I want to talk to you a little bit about something that Mr. Zhu didn't bring up on your direct examination, if you don't mind.
Okay.
Ma'am, you received a strategy memorandum purporting to be from the Heisman campaign while you were reporting on the election, right?
I got an anonymous tip that was left at my doorstep. It had that memo in it.
Ma'am, plaintiff's 4, that strategy memorandum, it should be on the table right in front of you. Do you see it?
Oh, I found it.
That's that same document, right?
Yes.
Ma'am, you were given that document while you were covering the race, right?
That's right.
So, naturally, you called the Heisman campaign to ask them if that statement was their campaign strategy, right?
Yes.
You asked them whether they were actually considering suppressing votes.
I asked them if anything in the memo was true.
Now, the
Phil,
first time
another
you called them, they
example-
said, the memo, it's not.
Another example of that same thing we've just been talking about, you can pronounce the word Y-O-U like you, or you can say yeah occasionally, right? And I think that just that like slight change makes things immediately more conversational. And so we would do that all the time. I mean, it's super minor, but I think you notice the difference.
Yeah, and that's one of a comment I give to, I mean, it's probably obvious to lots of people, but it's a comment that I give to newer competitors who like, you can say, did ya, could ya, like, that's fine. And you should say that because that's the way you talk. But yeah, I totally agree.
Real, right?
That's right.
The second time, you got passed all the way up to the campaign manager, right?
That's true. I spoke with Tom Lyon.
And Tom Lyon, he didn't just say it wasn't real, ma'am, he threatened you.
He just said that it wasn't real.
He threatened to sue you if you tried to publish that memorandum.
Notice that like
Sure, I didn't know.
it doesn't matter what she's saying, right? Like I'm not going to do the whole like that's not what I asked you. I asked you if you threatened. Just say it again, right? And keep moving. Another like sort of basic rule of cross, I think the faster it's moving, the more the attorney is controlling the narrative. The slower it moves, the more you really let the witness like drag things back to them, the more the witness tends to win. And I wasn't going to let her do that. I knew that that was her game. And so I was just going to try to steamroll as much as I could.
Well, I think that, and we'll watch it back. I think the thing that's important here is, I think generally you've got to attempt to control a witness in some form or fashion.
Totally.
The thing that makes what you did effective is that your next question is the control, right? You called and he threatened you, right? She says something non-responsive. He threatened to sue you. That's the next question is the control. Right?
Yeah, we would also call this like an umbrella question. Different programs call it different things. Harvard loved doing umbrella questions where we're fronting a thesis and it becomes like, don't think about pink elephants. Doesn't matter what she says next, because then I'm going to prove that the pink elephant was there all along, right? So you're sort of cluing in the jury. I want you to be thinking about this as a threat. Their first answer doesn't matter. Eventually we get back to proving the thesis in question 2 or 3.
It wasn't real.
He threatened to sue you if you tried to publish that memorandum.
Well, sure, I didn't know if it was real or not.
He said, if you try to publish that memo, I'll sue you for libel, Ms. Sandberg, right?
See, there it sounds like a threat.
It was clear to you that the campaign, they didn't want that memo to see the light of day.
Objection, Your Honor. Speculation.
Your Honor, I believe that this is rationally based on the witness's perception. She was threatened when she talked about publishing a memo. She can tell us that they didn't want it.
Ray this must have been a super casual courtroom. Ray with the folded arms during an objection argument. It may be because he's holding his pad there. That may be why. So did that question just come out wrong, or were you okay with the phrasing being a little bit sort of risky?
Oh no, I would ask it the same way now. I think, if someone calls and says, if you publish this, I'm going to sue you for libel, that's a threat. And you can ask it that way. That's absolutely rationally based on the witness's perception.
Well, I think your next question, I think that one is totally fair.
Yeah.
The next question that you ask, it was clear that the campaign did not want this memo to see the light of day. I think as phrase is certainly speculative. It sounds like you've said this already. It sounds like your style was kind of like, we're not we're not afraid to ask questions that are objectionable. We're
Yeah.
happy to have those fights.
There is the occasional moment, and you only get a few of these per trial, and I know I go there later, where you want to ask the question that you know is objectionable. You want the jury to know that you know it's objectionable, but you're going to ask it anyway because it helps to move your case's theory along. In real court, and this is a perfect example, I think, of a moment where if you had a coach in the room, they would say, you don't want to like walk the mistrial sort of fine line, right? Like you don't want to say the thing that is going to, you know, have this judge apoplectic. And I think that makes total sense. But I think in college mock trial, it is occasionally appropriate to say the thing that might be a little bit too far, as long as the jury knows that you know it was a little bit too far, and then you can withdraw. You can, I mean, there are plenty of things that you can do to sort of get yourself out of that box.
Yeah, it's just, I don't mean to sort of have the debate we had 20 minutes ago all over again, but
Yeah.
I guess my pushback to that is, I think it's interesting because I think some judges who are scoring these trials would agree with you and say risk taking is, I'm gonna reflect that positively in my scores.
Yeah.
But I guess my concern would be if I'm a scoring judge and I'm a trial lawyer and I'm hearing you or a teammate do a cross-examination and you ask a question that I perceive to be, as you just said, sort of maybe a bridge too far or just, you know, above the line. I wouldn't do that. I don't think that's appropriate in a trial setting, whatever it is. Aren't you concerned that that trial lawyer is going to reflect that in their scores, even though they know that, you know, it's across the line?
Yeah. I mean, you're always playing with the concern. I think when you are too concerned about everything that you do, you end up being such a conservative team that you can't win. I think that the right course is to sort of prove that you understand what the rules of the game are. You know, you understand what is and is not objectionable, and then to sort of tip your cards. But I'm going to do this slightly objectionable thing here because it's strategically important. And if you make those calls appropriately, I think you can look dynamic, strategic, creative, a little, you know, more willing to take risks, and those teams tend to win.
The interesting thing about this round, sort of in hindsight, is there were 5 ballots, you won 4 and tied the other.
Yeah.
And you guys lost a lot of objections in this round, and it didn't seem to matter on anyone's ballot. In some ways, that supports what you're saying, which is that being risky is worth it.
Yeah.
So I just find it super interesting. And I think you're right that if you're too conservative, you're not going to win.
Yeah. I think so the context leading into this cross, if you look back at this direct, and then I think their expert direct, both Zach and I objected quite a bit. We did lose a bunch of those objections, but the objections set the stage for what we would then cross on. And a comment that I remember Dan Young making in the jury was, he said, you know, your crosses, and particularly the objections that you made to support those crosses before they even began, really made the difference. And I think, you know, good trial lawyers, in the same way that Dan stood up to ask how much time was left, good trial lawyers present a narrative before they're even in the spotlight, right? So that their narrative is always in the jury's mind. And so I had the jury, hopefully, thinking before this cross, you know, her story on this, you know, stolen election maybe was a little bit deceptive, and there was something else going on with this shady character.
It was clear to you that the campaign, they didn't want that memo to see the light of day.
Objection, Your Honor. Speculation.
Your Honor, I believe that this is rationally based on the witness's perception. She was threatened when she talked about publishing a memo. She can tell us that they didn't want it published.
If I may be heard, Your Honor. Just like her opinion isn't relevant on direct examination about Ms. Ginger's actions, her opinion about what the campaign may have wanted or not wanted certainly isn't relevant here.
Counsel, you can ask her questions that may go to her perception of what was going on, but not as to what was being perceived by the campaign itself.
Certainly. Ma'am, the campaign, specifically, they told you that they did not want that memorandum published, right?
That's right.
Well, let's talk about what that memorandum said, ma'am. You'll agree with me that that campaign strategy memo.
Do you see that okay, ma'am?
Not quite.
I always thought that was super smart for her to say, not quite, that she couldn't see it. It's the same thing with Dan, like inserting herself. I like that she did that.
There are a few sort of they're almost mock trial FUs, right?
Yeah.
Like one is you walk up to opposing counsel with the document. To which page will you be referring?
Right.
That's like that's FU number one. FU number two is the document in its entirety, right? And they're like, those things are terrible, and I'm sure they still happen constantly. I kind of judge the witness saying, I can't quite see. She knows exactly what the memo says, right? It's like, yeah, I mean, you're in the game, I get it. But yeah.
I mean, especially when you're going against a good cross examiner like you are.
Yeah.
Finding opportunities to disagree or make it look like you did something wrong, even as minor as
Totally.
not putting a blow up in the right place. I think it's a shot worth taking. In the context of this round, at least.
No, I don't blame her for taking the shot, for sure.
Can you see it now, Ms. Sandberg?
Yes.
Members of the jury? Ms. Sandberg, that strategy memo, it said that the strategy would be to persuade people not to vote, right?
Yes, that's right. That's what it said.
It said that the strategy would be to reduce the votes of low education, low-income voters in District 12, right?
That's correct.
Ma'am, this is the same memo that the campaign manager told you he didn't want to see published, right?
That's right.
So, ma'am, naturally, you wanted to figure out whether the campaign would actually try to pursue a strategy like that, right?
Well, sure.
So you went to the polling places on Election Day.
Oh, yeah, I went there. I was in Bellevue.
And you heard voters in line in District 12 asking questions, didn't you, ma'am?
I heard them talking amongst themselves. Sure.
You heard them asking questions about the requirements for voting, right?
Yep, they were talking about voter requirements.
They sounded concerned about whether or not they could vote.
I don't know if they sounded concerned. I remember them talking about voter requirements.
Ma'am, you recall making an affidavit prior to today's case, right?
Sure.
Ma'am, those voters were concerned when you heard them talking in line.
So this is going to seem minor, but it's, in my experience as a coach, it's one of the couple of comments that I give most frequently to high-level competitors, which is competitors for some reason are very hesitant to threaten an impeachment when they're correct.
I've never understood that.
And the lesson to take away from, and we'll watch it back so people can see what I'm talking about, is it is the quickest I've ever seen someone hear an answer and have the witness statement in their hand and threaten the impeachment. It's just immediate. And it shows a command of the facts of the case. It shows it's effective cross-examination. It makes the witness back down. It's just good.
It tends to only work if you really know the material, or if you can just be really convincing. I wonder which of the two this was. I mean, occasionally I would do that and then like glance down and realize I was wrong and just move on. But most of the time when you would threaten, witnesses would back down.
Yeah. And the word concerned, my guess is, I don't remember what this case said, but my guess is the word concerned was probably in there. And
yeah, that's a Justin word. Yeah.
Right.
I don't know if they sounded concerned. I remember them talking about voter requirements.
Ma'am, you recall making an affidavit prior to today's case.
It's already in your hand.
Ma'am, those voters were concerned when you heard them talking in line at District.
I don't want to make too much of it. It's already open in your hand with the page open.
It probably was Jordan passing it to me in the middle at council table. I mean, I think when you're off, you should not just be sitting there trying to memorize your own material. You should be actively helping co-counsel, right? I mean, it's wild to me to see attorneys in court today, right, not actively listening to their co-counsel doing something like this, right? Like you can have the document up, handed to them, ready to go, right? Like you play like a really vital role in that situation.
It's one of the only things as a coach that makes me legitimately angry is when a team, like you said, when your co-counsel is not following along with the cross, deposition, affidavit in hand, waiting, handing exhibits to you rather than making you have to pick them up. It shows teamwork and it makes everything feel smoother. So yeah, I mean, it looked really good for you in that spot, but it probably is more of a credit to Jordan or Zach or whoever handed it to you.
Yeah, I think it probably is.
But to be clear, ma'am, you hadn't heard those concerns about voting requirements in District 1 earlier that morning, right?
I don't recall that.
You hadn't heard them in District 2?
No.
Ma'am, you hadn't heard those concerns about voting requirements in any district in the city except District 12?
I only really spent time at the polling place in District 12, so I couldn't tell you much about the other districts.
That's the only place where you heard concerns about voting requirements, right?
That's right.
So naturally, you went up to those voters to ask them why they were worried, right?
Oh, sure.
But, ma'am, when you tried to ask them why they were concerned, a man stopped you, didn't he?
Yeah, there are rules about talking to people in line to vote. I wasn't allowed to do that.
A man came up to you and he said, stop asking those voters questions, right?
That's right.
Ma'am, that was this man, the man depicted in Plaintiff's Exhibit 3, right?
Yes, looks like him.
He didn't just tell you to stop asking voters questions, he threatened you, didn't he?
He pretty much kicked me out. Yep.
He said, if you keep asking these questions about voting requirements, I'm going to throw you in jail, right?
Yeah, I didn't have my press ID on me, so he thought I was campaigning, I think.
I mean, to the point that you made earlier about sort of the rhythm of the cross and stuff, you almost, this witness is excellent. I think she was in,
so good.
she was in the next year's final for sure.
Yeah.
But you almost forget she's there during the cross. I mean, you sort of forget the shtick, you forget the character. And that's why, to the point discussion we were having a few minutes ago where she says, I can't see the blow up. It's almost like she needs to do that at that point to sort of disrupt this a little bit.
Yeah, I think that's right. I mean, fortunately, this cross had such good dramatic material built into the affidavit, right? Like, I'm not the kind of person who can occupy that space, right? Like, I am not Dan Stern. Dan Stern can occupy that space just by like speaking and filling up the room and, sort of being that person. I think when you realize that you're not going to be able to do that, the way that you can be really good is to create these like dramatic moments. And we were doing it with a lot of those umbrella questions, right? Like, you'll notice the word echo of threatened, right? Like, oh, she was threatened. She was threatened first by the campaign. Then she was threatened by this guy. We were trying to make like small moments dramatic so that the jury, they're just thinking, wait, whoa, she was threatened again. Like, let me hang my hat there. I don't really care what she says. I'm waiting for the next question. I think sometimes that can be a really effective way to occupy space, even if you're not the kind of person who would normally occupy space. And the other thing that I'll say on that point is physically occupying the space can be really important. I am a short person, right? I'm like 5'7" on a good day. And so I was like trying to walk around as much as I could, using hands up here, using hands here, like really acting it out. It looks way over the top, and I probably wouldn't do that in any other context. But I think in AMTA, especially in a round like this, where we knew they were going to dominate the space of the courtroom, we started trying to use as many of those little tricks as we could.
So this was a swing witness, as we talked about a few minutes ago.
Yeah.
Was this your primary cross, or was this one you sort of had as a backup?
I don't remember.
It's possible that it was a primary only because I think there were only 8 or 9 witnesses in this case.
That sounds right.
It was the test case for nationals, so they wanted to keep it smaller. I think it's always this generally anyway. The other question I wanted to ask you is, we are now probably like 70% through the cross. Having watched it, is there anything that you would do differently performatively or substantively or from a technical perspective?
Yeah, I mean, I think, this is late in the trial and I knew that I had closing to go. But the thing that I always tell competitors is you want to show 3 different kinds of range throughout a trial, right? You want to show a range on volume, right? You can be really quiet. You can also be really loud, right? Like 1 to 10, or, more realistically, like 3 to 9. You want to use that range. You want to show range on tone, right? That you can be somber. You can also be sort of righteously indignant. And you want to show range on speed. And what I've heard so far in this cross is almost same level volume, tone, and speed. And I think I probably was doing that because I felt like I had enough places elsewhere in the trial to show those other sort of pieces in the toolbox. If I were like middling in this round, I probably would have tried to be a little bit more dynamic on each of those metrics during the cross.
Yeah, I think I think the thing that you do really well in this cross from a performance standpoint is, and again, it sort of sounds simple, but I think it's one of your better performative skills is you're a very good enunciator. You speak very clearly. And when I'm evaluating, no, you never, I mean, you watch it back. I don't think you stumble or sort of fumble over your words at any point throughout the trial. And when I'm evaluating a tryout for a new competitor, that's one of the sort of the metrics that I'm looking at. Okay, does this person speak clearly? Can they speak? Do they enunciate their words? And
Sure.
that matters to me. And I think you do that as well as anyone. And I think that's one of the things that differentiates you from someone like Dan, who's a really high level competitor, but maybe not as smooth is the wrong word, because Dan is very smooth. But you're sort of a little bit more steady than he is in that regard.
Interesting.
Like any good reporter, you wanted to figure out who that man was, right, man?
Just as you say, I don't fumble.
Right.
So at a press conference,
You know what's funny though?
just after the
Watching, I've seen this cross before, and so watching that, you like, it doesn't even faze you that you dropped the piece of paper.
Yeah.
And just like you just casually pick it up as if nothing happened. And we've all been in trials in big rounds where someone will knock something over, and it ends up being really awkward for a few seconds. And that's the way to drop a piece of paper if you're going to drop a piece of paper.
That was totally unintentional, dropping the paper, I promise you. And I was probably internally like, oh, damn, what did I just do? But I do know that some competitors, and I'm not going to say his name, but he was a predecessor of mine. He had this theory that if you intentionally like bump into the table a couple of times, you look less robotic. And people kind of like the sort of klutzy, like, oh, yeah, he was trying and he like kind of screwed up. Like it's kind of cute, right?
Right.
Like, I think if you can pull that off, it can be effective. This was not at all intentional. I'm just like a very clumsy person.
election took place, you and one of your colleagues, you asked the mayor if he'd ever met that man, right?
Another one of my colleagues did, yes.
The mayor, to be clear, she said no, right?
That's right.
She said she had never seen the person in that photo in her entire life, right?
That's what I heard.
But ma'am, you know that was a lie, don't you?
It's true. I went down to the police department and had a pal of mine give me a criminal record.
You
Okay,
recognize
guys.
that criminal record?
I've always felt like so you were saying things that rub judges the wrong way. A lot of judges would say never use the word lie. I think if you have a direct lie, you should use the word. And I've always felt that way. I think if we had been trying this case in different circumstances, like if we either weren't like, I don't know, in a place where I felt like the judges were going to be okay with it, I might not have said it. Here, I knew that all of the judges were former AMTA competitors except for the presider. I felt like we could probably get away with it. But that's always frustrated me, that it's like something that people shy away from. I think it's totally appropriate if, like what you were talking about is a lie, an intentional lie, right?
Yeah.
I think you should absolutely use the word.
Yeah. So I'm sure this is going to be shocking to hear given what I've said so far in this episode, but I tended to be a very conservative competitor and I'm a conservative coach. But one of the sort of truisms that I push up against and just I don't agree with is exactly what you just said. The concept of never say the word lie. There are some times, and again, to bring this whole episode full circle, this is where having a coach, a lawyer is helpful. Like there are some times where saying something as a lie is improper and there's case law on it. But if someone lied, right, and you have them on the stand and you're like, that was a lie, you can say that, right? It's a fact, right? It's a matter of fact at that point. I think the distinction is drawn where an attorney in closing argument, for example, gives his or her opinion regarding whether something is truthful or not, or the credibility of a witness, based on their opinion and not the evidence, something like that. But certainly here, I think it wasn't even close to the line, and I agree with you. It's one of those sort of things that I sort of think is just wrong. A lot of people have been led to believe. It's
kind of like everything. In second grade, you learn don't start sentences with the word because until you learn that you totally can. I think at the highest levels, college competitors break some of those old rules. And I think that it can be effective in the right moments.
Mr. Zhu and the witness in turn with what's pre-marked as plenty of 7.
That's right.
Your Honor, you like that?
Yes, I do. Thank you.
Ms. Sandberg, that's that criminal record that you were given by the police department, right?
Looks like it, yep.
And on the first page there, that's an official certification of this as a public record in the city of Truman, right?
Yeah.
Doesn't look like it's been changed or altered in any way.
Nope.
Your Honor, at this time, the plaintiff offers Exhibit 7.
We'd object, Your Honor. Under 403, more prejudicial than probative, may I be heard?
Sure.
A long list of the criminal record of this man, Casey French, isn't probative. First of all, a lot of those things that he's been accused of, they aren't probative in today's case at all. And secondly, the ones that are probative,
just to put this in some more context, Casey French was a person that the plaintiff alleged the mayor had hired to essentially carry out this plan to dissuade people in a certain district from voting by like handing out flyers and making a phone call saying you can't vote if you're not a college graduate or whatever it was.
Yeah.
And so this exhibit is a document. I think it was something like an email or something like that sent to the mayor regarding who this person was and what their background was.
The mayor had previously represented him as a public defender, and this was his criminal record. And so I think it was like a record of all of the cases in which she had represented him.
Right. And that she was the lawyer in that case.
Exactly. I think it's super objectionable. I don't know that I would have gone with 403, although I'm like struggling sitting here to think about how else it should have been used.
Well, isn't it potentially propensity?
I mean, sure, but it's not a criminal case. He's not like, I mean, yeah, it is.
It depends on what your theory is. The defense is. If your theory is this didn't happen,
right,
it's certainly propensity because you're saying he's a criminal once, he did something criminal here, or he's a wrongdoer once, he did a bad thing here.
Yeah, I think the reason Ray didn't go there. I mean, you're right that it like goes through the character propensity box. Like, I think the reason that would have been a weaker objection is that it's very easy to say this just goes to the defendant's knowledge, right? Like whether he was someone who had done things like this in the past, right? I feel like anytime you can move up against motive, intent, knowledge kind of territory, judges tend to let character evidence in. And this was one of the few places where it really did feel like it was just about the defendant's knowledge. Like, who cares what Casey French has actually done? What matters is what the defendant thinks he has done. And so I'm not sure that character evidence would have fit, but like maybe even just hearsay, right? Like why is any of this stuff? I think that's why I led with the public record piece to set up like a potential public record exception.
I forget what the exhibit looked like, but typically criminal history records are.
Yeah.
I think the other reason that Ray can't make that argument, I think probably the simplest reason is their theory is not that it didn't happen. The theory is that it didn't happen, but it did happen. We had nothing to do with it though.
I think that's probably right.
So they're not arguing that he's not a criminal. In fact, they're embracing that. They're saying he did it. He did the stuff. Whoever this guy is, he did it on his own. We had nothing to do with this.
I think
it's kind of disingenuous to make the 404 argument. Which is by Ray.
9.99999 times out of 10, 403 is not a great argument. Like, unless you have something that is just so obviously more prejudicial than probative, I think mock trial judges are always going to let in things over 403 objections. So when he led with 403, I was like, this is like a really objectionable document. I'm not sure I would have led with that.
Yeah, I think that's another one of my sort of pet peeves as a coach or a judge is that I hate relevance objections and I hate 403 objections. They're largely you're never going to win them. And the worst part about those kinds of objections, you're giving your opponent an opportunity to score points.
Yeah, I mean, when you get a relevance objection, you should make a mini closing argument. The one exception, I think, to your relevance point is a nested relevance objection. So, objection hearsay. Your Honor, we're not offering it for the truth of the matter asserted. We're just offering it to show the effect on the listener. Comes back to the first person. If that's the case, then the statement itself is completely irrelevant. Like if all you care about is the effect on the listener, right? Like we can get there without the statement. I think that can often be really effective, but leading with a relevance objection, I agree. Yeah, the other issue with those objections is most times mock trial judges are not paying attention. Yeah. And if they are paying attention, they're paying half attention. They don't really understand where this is headed substantively, but they just are, this guy sounds good or this guy doesn't sound good, whatever it is. But you're giving your opponent an opportunity to highlight for the people that are listening why this all matters. I think that's right. So I think generally, for newer competitors, you want to stay away from those in limited circumstances, at least.
Charges where Mayor Heisman represented him, he was found not guilty. Certainly this criminal record will inflame the passions of the jury and is more prejudicial than probative. If opposing counsel is trying to use this to establish the relationship between Mayor Heisman and Casey French, we'd be happy to stipulate that Mayor Heisman represented him, but at this point there's no probative value.
Your Honor, may I respond? We aren't just offering this to show a relationship between the defendant and Mr. French, although that is part of the reason we're offering this document. Specifically, Your Honor, we're offering this criminal record to show that the defendant had knowledge that Mr. French was capable of committing fraud, that he had a history of impersonating police officers, and it makes it more likely than not that the defendant would have sought him out when the defendant decided to commit election fraud to steal the votes in this election.
Your Honor.
Didn't the mayor already testify as to the charges she represented this guy on?
Your Honor, I don't believe the mayor ever told us that this man was accused of fraud each of those times, and Your Honor, we certainly didn't hear that this man was convicted of impersonating a police officer.
Your Honor.
So that's
so inappropriate. What I just did, I mean, like in obviously the jury would not be there. This would be at sidebar. But like the whole goal there was to front, even if this stuff doesn't come in, I'm going to have the jury hear all of the things that this person was convicted of doing, and I have connected it back to the defendant. So you sort of make it a win-win, right? Either you lose, but they heard your whole theory before, you know, the objection was ruled upon, or you win and it's all sort of icing on the cake.
at the risk of insulting a real judge here.
Yeah.
I actually think what you did was totally appropriate because, and there were a couple times during the course of this trial, if you watch the whole thing, where the judge sort of stopped you guys from making certain arguments, or like, oh, I don't need to, we don't need to get into the details of, out loud on that point, as if the jury were like there. They're not there. I mean, we're at sidebar in theory.
Yeah.
So I don't think there's anything inappropriate about you. In fact, I think you need to tell the judge what the charges are to sort of inform him as to substantively why this all matters. So I think that's totally great. Totally right.
That's totally fair, right? Like, it would not be inappropriate at sidebar. I think I was like basically saying the jury hasn't heard this thing, hinting to the jury, like, hear this thing now. I mean, that's so beyond the pale, right? But I think it sort of worked in context, understanding that they would sort of think we're at sidebar, but yeah.
Yeah, I mean, maybe where it crosses the line potentially is there were a couple times there where you sort of turn to the jury and almost like kind of make the argument to them. Right. So I would be concerned that maybe they are like, well, we're not supposed to be here. And to the extent that you're telling us this, it's inappropriate. So don't.
Yeah.
I'm not going to juror disregard that third sidebar with what you said. Go ahead.
Your Honor, certainly then it is more prejudicial than probative if they're trying to use this evidence to suggest that the mayor would have gone to this man to commit fraud because he was found not guilty. The man was found not guilty of fraud. Certainly the jury can't see that because
you can make that argument when you get to that point, but I'm going to let counsel run through the 3 dates and the
So I didn't realize he was not convicted of fraud.
Yeah.
I think it's a really smart. That is the smart argument by Ray.
Totally. Obviously very conveniently left that out. I don't remember the document, but agreed. Very, very smart argument.
I don't remember what the judge did with this. Let's see.
Charges involving the mayor's representation of this person, but the rest of the record is not in this.
I think he sustained it. He sustained it with respect to the specifics.
Let's take those one by one, Ms. Sandberg. You found that this man, the man that the mayor denied knowing, was represented by Mayor Heisman in 2001, right?
That's right.
Specifically, he was represented by the mayor when he was accused of fraud, right?
Yes.
Impersonating public officials.
So maybe
Yes,
not
that's
then.
what it says here.
The very next
I think
year,
It wasn't super clear what the ruling was.
I think what he said was, I'm not going to let you get into the convictions themselves, but I will let you go through the dates and the charges, which, if anything, I think is probably slightly misleading, because then the jury thinks like, oh, he was convicted of all of this stuff.
It's the only wrong way to do this. So not, again, at the risk of insulting a real judge, but why would the conviction be out but the charge be in?
I think because, I mean, I don't know. I actually don't know that this is wrong. Because we were just offering the document to show the defendant's knowledge that this person had been accused of doing these kinds of things in the past, like the end result of those trials really doesn't matter, right? It's not like he's on trial. The defendant is on trial, and the defendant represented him knowing that this person had been accused of doing these things in the past. It changes the way that she might think about using him for this purported fraud.
But doesn't it change the way she thinks about using him if he did do it or if he actually didn't do it?
That's very different than whether he was convicted, right? I mean, she was his counsel. Like, we're not asking, you know, for all we know, he's found not guilty, but he told her in a privileged setting that he did in fact commit this fraud. I think all that mattered was, she knew that this person that she had represented in all of these different contexts had been accused of doing these things.
Well, we also don't know, I guess, if I don't remember the document either, but maybe there were some of them were pleas of guilty, in which case, I mean, I guess you could plead guilty and not have done it theoretically, but
Every day, yeah.
right.
He was represented once again by the mayor, right?
That's right.
And once again, he was accused of fraud, right?
Yes, sir.
Of impersonating a police officer.
Looks like it, yep.
2 years later, ma'am, in 2004, he was represented once again by Mayor Heisman, right?
Yes.
And this time, he was accused of fraud and impersonating a police officer.
Yes, sir.
Ma'am, if someone wanted to commit fraud, would they be more or less able to do that if they knew a person who was able to do those things?
Objection, Your Honor.
Sustained without argument.
Withdrawn, Your Honor. Ms.
Yeah,
Sandberg.
that's one of those moments. It's so clearly beyond the line, right? Like you hear laughs in the background. I probably didn't need to do it here, but I know it was built in to sort of drive that point home, right? And my immediate withdrawn, like I knew it was super objectionable. This is never something as a coach that I would encourage a student to do, but I understand why I made the
Right.
right. It's like move this narrative to that last step, and like the like classic comeback from a judge is going to be you ask the question too far and like never ask the question too far. I think it's actually okay sometimes if you immediately cut to the withdrawn. Like I know it was objectionable, but I was doing that to sort of ring the bell.
It's certainly a polarizing choice. And the interesting thing, sort of about the choices you're making, and I mean, frankly, the choices that you guys made throughout this trial, is that for a team that's so dominant throughout the season, and for a team that I think had such a wide talent advantage, the three of you are excellent. I mean, one of the we haven't talked about Zach Lustbader at all in this episode, but he's an incredible competitor.
Yeah, incredibly good.
And I think Jordan's Harvard team did really well when he was a senior, when the two of you had graduated, and he led that team. This is a very talented team, and I'm a firm believer in the sort of strategy that when you're Goliath, you don't take David's strategies, right? Which are, sort of doing things that are super risky. So in some ways, it's bold for you guys to say, we've got a wide talent gap, and we're the heavy favorite, and we're still going to take risks. And that's probably why you guys dominated all season, because you had both.
Yeah, I don't think that we would have taken these risks in every round, though, right? Like in the first minute and a half, if you watch this video, I don't know if it pans to our table at any point, but if you watch this video during Ray's opening, the three of us suddenly realized this is going to be a really close round, and we might already be behind, right, from openings onward. I think that compelled us to take risks. We made way more objections than we normally have made. We felt like if we let them own the space, we were going to lose. And so we'd come all this way. In some ways, what we do in this round was not reflective of what we had done the rest of the year.
I think the openings in this trial are the best openings in a national championship ever.
Wow.
I think no doubt. I mean, Zach's opening is really, really good.
It is.
And Ray's, we talked about this before the episode started. I think Ray's opening in this trial is probably the most ripped thing in AMTA history.
Yeah.
I mean, just like this weekend, we just had the trial by combat play-in tournament recently at the time of recording this. And in the final round, Michael Chandler, who is an excellent competitor from Brown, is doing the what if I told you thing in his defense opening. And he's not the only high level competitor that uses that sort of that sort of verbiage at the top of their D opening. And it's really effective. And like a decade later, people are still doing it. It's crazy.
It was two things that they were doing, right? One was, the performance piece was incredible, I thought. And I think a lot of that was driven by sort of Dan's theory of how mock trial should work. The other was, it was very inventive, right? Like their leeches thing, if you watch this full trial, doesn't appear in the case materials at all, to my memory.
Right.
So, I mean, we were never the kind of team that was going to be like, oh, you invented that fact, right? Like we were going to play them on their turf and hopefully beat them. And I think that was kind of our theory for how this dynamic should work. But we thought immediately they're creative and they can really perform. And so we've got to find ways to differentiate ourselves, and, slightly riskier objections, slightly riskier cross questions. That's one way that you can try to do it.
And for people who don't know what you're talking about with the leech thing, I think one of the big D theories was that the challenger was doing well in the polls and committed sort of like the equivalent of like it was the Romney thing, right? Saying, committed some gaffe sort of late in the cycle.
Yeah.
And I don't, like, to your point, I don't think like it was spelled out in the way that Yale used it earlier in this trial, which is that most of the people in District 12 are leeches or take more than their fair share or something like that.
Yeah.
So you're right. It was certainly inventive and sort of foreshadows the way that Yale, played in the subsequent finals.
You'll agree with me that when the mayor stood in front of that room of press reporters and talked to the citizens of Truman, she denied ever having met Casey French in the first place.
That's true.
But what your reporting revealed, or what your evidence found, was that she did know that man, right?
That's what this is. Yep.
That she'd represented him 3 different times.
Yes.
Thank you, Ms. Sandberg. No further questions, Your Honor.
I can tell that what I was doing there, so that question too far was designed to potentially be a last question. And if the objection came and I withdrew, you had to have some other spin down, right? Like never end with a sustained objection or a withdrawn question. So it was like a designed spin down where I hadn't technically asked those questions before, but they were totally unnecessary.
Right. I mean, I always like to have, and certainly the teams that I coach have a backup cross section just in case something goes awry at the end. Right. That we're not ending on that. So that was the cross. And like we said earlier, you guys would go on to win this round 4-0-1. So a decisive victory over a historically good Yale team. How did it feel when they said that you guys had won the trial, and after years of sort of getting close and your last trial ever, finally capturing the national championship?
It was huge. I mean, it felt like a close round the whole time, right? Like the ballot count still surprises me, right? We, I think, lost the statements. So I mean, it was close, and so we were elated, right? Like I think you've got 7 competitors, the 6 of us who competed, and Eric Bakke, who wasn't in this round but was another attorney. We were the 7 there when it happened, but really the championship had been built, on like 15 years plus of really good Harvard teams that kept passing down knowledge, right? We had this like seminar program that the college still runs for high school students. That's kind of how we would train each other. A lot of the sort of tricks that we used were honed and developed by, plenty of folks over the years.
So one of I would say that among the most watched mock trial rounds ever, this round is certainly in that class of most watched rounds. I would say this one, the UVA Yale final round from the next year, Ben and Rahul's Top Gun rounds, 2011 round between UCLA and NYU. I'd say those are the 5 most watched mock trial rounds ever. How does it feel that people, we're going on a decade later, are watching this trial and learning from you and learning from your teammates, and in some ways copying things that you guys did that they like? Does it sort of occur to you that that's happening, and how surreal is it?
I think it's awesome. I mean, it's when we were in that round, we certainly didn't think that, this was going to be a video that people were watching later on. I think having now been on the other side of it and at least coached some law school competitors, I realize how hard it is to get your hands on like good teaching material. And I think these rounds can be, hopefully helpful. I mean, it's kind of crazy. In a lot of ways, when I watch, what we were just looking at now, I think, as I said before, there's like this creative space that people have in college mock trial that kind of gets whittled down afterward. And so it's like I'm watching like peak, Jordan and Zach and Neil and Lila before we all like went to law school and had like a little bit of that creative spirit like beaten out of us. And I think, it's cool to look back at this round and think about what we thought good trial work looked like then.
It's such a good round because it's instructive in so many ways. Like I talked about the witness thing earlier. And you guys are all so different. You're substantive, you're good performers. There's a ton of objections. There's a lot of sort of technical stuff in terms of like witness control and courtroom decorum and things like that. I also think, just like frankly, and I hope this isn't sort of insulting to the 12 of you, but I think there's lots of good moments where I would say to a competitor, okay, Zach can get away with that, but you can't, right? Or Dan can
Yeah.
get away with that, but you can't.
Yeah.
And here's why he can do it in this moment. And here's why that witness can say that in this moment. And here's why you generally shouldn't do that.
Yeah, I think that's absolutely right.
And sometimes the high level rounds are sort of the good schools doing the things that we would all expect good teams to do. But the thing that's so fun about this round is it's so different than what you would see, what you'd seen up to that point for sure. And I think even what you've seen subsequently in final rounds. And it's particularly you and Dan are just so different than sort of the big competitors that we'd seen in rounds before that and after that in terms of your styles. Was that sort of apparent to you?
I don't think that I was that different. I think Dan was. I think like listening to him sort of own the space, I thought, yeah, this is a completely different style, one that I was not familiar with. We were reacting to it in real time. But I think what I was doing was, in some ways, just a derivative of what I had seen like all along, right? From like, remember when I was a freshman, like crossed by, Ben Wallace and Brandon Hughes and like all of these people that I was like, oh my God, they know what they're doing. I think it was in some sense just a derivation of the formulas that I had seen work, sort of coupled with what I felt like was somewhat authentic.
Before I let you go, I have one question for you, and this is a question that I ask a lot of our guests, or most of our guests, but the question is particularly appropriate for you. I ask competitors or coaches, alums, who the best competitor of all time is, and when people come on the show and answer that question, I get a couple of names, all the time. The most recent name that we hear all the time is Sidney Gaskins and Ben Wallace, but you are the name that comes up. Dan Stern, obviously, and you are the other name that comes up all the time. How does that make you feel?
That was really nice. I mean, I think it's kind of ridiculous because like none of us have seen all of the competitors from all time, right? Like my window is like 2010 to 2017, maybe.
Yeah, but isn't it fun to just speculate with no basis on things like this?
Yeah, no, that's the best. I mean, it tells me that probably the people that you were having on were from that same sort of time frame, and
or the very
really
next the very next generation of competitor that are looking at people like you in the same way that you and I looked at Ben Wallace, which is
I think that's right.
sort of Titan that is just sort of like this figure that I could never aspire to be as good as.
Yeah, I think that's probably right.
So who would you say the best competitor of all time is?
Can I cheat? Do I have to give one answer?
I'll let you cheat within reason.
A little bit. I think that well, so from what I saw, right, which is like obviously very different than like an all-time thing. From what I saw, Dan was doing something so different than everybody else and so occupies the space. I'm actually really sad that he's not going to be an attorney unless he like decides to stop coaching. I think he's so naturally gifted at telling stories. Like he is a storyteller at heart in a really incredible way. And that's in a lot of ways what I was aspiring to do. I think he pulled it off so effortlessly. So I think natural ability, probably Dan. In terms of like understanding the technical and very different ways that people can be mock trial attorneys, I would probably say Ian Lampert. I mean, he can just do everything, right? He can play the like Ben Wallace character. He can, come pretty close to doing the sort of Dan occupy the space. And I think it makes sense that he is coaching people to do so many different kinds of things. Like he understood it and he was able to sort of capture and reproduce some element of a bunch of different styles really well.
How much are you paying attention to what's going on in the active circuit, currently?
Not very much. This last year, I judged one round at Columbia's tournament, sort of as a favor. I thought it was a fun case. And then I judged a scrimmage between what I guess ended up being the final round teams, UCLA and Harvard. I've kept up with the Harvard team a little bit, but otherwise I haven't paid much attention. The quality of competition, I think, has only continued to excel. that has certainly not changed.
So tell the people who may not know what you're doing right now professionally.
So I'm clerking on the Southern District of New York for a district judge for a few more months. I'm almost done with the clerkship years, and then I'm headed to Sussman Godfrey here in New York, which should be a good time.
So you mentioned that you recently had been coaching at UCLA Law. You mentioned that you'd done some judging. Do you expect that you'll be back sort of participating in the mock trial circuit, whether it be high school or college or law school level to some degree in the foreseeable future?
At some point, yeah. I mean, I think the people who make this competition work really don't get enough credit, right? You know, from the tab directors to I mean, that year, right? It was like Justin and Jonathan Woodward, like all that they put into making the competition work. I think only now do I see how critical that space was, right? It was like this super stressful time, and especially for uncoached teams to have like really thoughtful people spending that much time working on this. That's so meaningful. And yeah, at some point I would love to be involved in some capacity. I don't really know what it's going to look like yet.
Well, Zach, I super appreciate you coming on the show. And when I started this series a couple of years ago, one of the things that was sort of on the short list for things I wanted to do was have you on to watch this parts of this trial. So I'm happy we got it done.
Yeah, now I disappointed you.
Definitely not. This is going to be one of the most watched episodes.
Well, thanks for having me, Phil. This was a lot of fun.